Good morning, good afternoon, good evening to you tribe blockers all over the world. We're so grateful to have you back with us, but unfortunately it's for the final time. Could you believe our 3 weeks have gone by this quickly? Nonetheless, tonight we have something spectacular for you because this is the last session of our compliance sprint. In session 1, we covered contracts, your records, and essentially your paper trail. In session 2, we covered NIB rates, the insurable wage ceiling, and your C10 filing obligations. Today, we're going to talk about the full employment lifecycle, from the day somebody joins your team to the day they have to leave. We're covering work permits for non-Bahamian hires, the leave entitlements your team is legally owed, notice periods, severance, and the termination process that the Employment Act requires. If your business operates anywhere in the Bahamas and you've ever had a termination that did not go smoothly, or you're not sure what you owe when employment ends, today is specifically for you. Compliance Handbook is your reference. Our Compliance Handbook that's in our chat right now is your Bible for the next several minutes with us. So, start at hiring. For Bahamian employees, the compliance steps are what we covered in session 1. Written contract from day 1. NIB registration within 7 days, and proper records on file. For non-Bahamian nationals, there's one more requirement, a valid work permit. Work permits in the Bahamas are issued by the Department of Immigration. They are required before the person starts work, not while the application is in progress, not after the first week, before. If you're operating without a valid work permit, even during a renewal gap, your business is exposed. The Compliance Handbook is direct on this. There are no exceptions. Start work permit applications at least 3 months before the intended start date. Most permits require annual renewal as well. Track those expiry dates carefully. Don't let a renewal slip. The full work permit guidance is in section 11 of the Compliance Handbook, and you can find that on page 13. Leave is a compliance obligation, y'all, not a benefit your business chooses to offer. The Employment Act sets the minimums, and those minimums are non-negotiable. Annual leave. After 1 year of service, your employees are entitled to 2 weeks, that's 10 working days, of paid annual leave. The entitlement increases at 5 years of continuous service. Check the current Employment Act provisions for the updated figure. When it comes to sick leave, your employees are entitled to 14 days of paid sick leave per year. You can require a medical certificate for absences beyond 2 consecutive days. For an illness that extends beyond sick leave, employees can claim NIB sickness benefit directly. What about maternity leave then? Maternity leave is now 12 weeks total. The first 8 weeks are at full pay, employer funded. Weeks 9 through 12 are at half pay, also employer funded. Additionally, employees can claim NIB maternity benefit at 66.67% of their insurable weekly wage directly from NIB. Maternity leave is job protected. An employee returning from maternity leave is entitled to their original role or an equivalent position. Dismissing an employee because she became pregnant is unlawful. Public holidays, the Bahamas has 11 of them. Lord of mercy, I know. Your employees are entitled to their regular wages on each one. If you require someone to work a public holiday, they're entitled to additional compensation. Confirm the current premium pay requirements under the Employment Act every time. These entitlements apply from the moment the relevant service threshold is met, not from whenever you decide to activate them. If your contracts or policies currently sit below these minimums, they need to change right now. Full leave entitlements are in section 4 of our handbook, found on page 7. Now, what happens when an employment ends through resignation or termination? Notice is required from both sides. The Employment Act ties the required notice period to length of service. Less than 1 year equals 1 week's notice. 1 to 5 years is 2 weeks' notice. 5 or more years is 4 weeks' notice or 1 month's wage, whichever is greater. The obligation runs both ways. You give it when you're ending employment. Your employee gives it when they're resigning. Notice must be given in accordance with whichever is more favorable to the employee, the act or the contract. If your contract offers more than the statutory minimum, the contract governs. If it offers less, the act overrides it. One exception, summary dismissal for gross misconduct. The Act allows termination without notice, but a fair disciplinary process must still be followed and documented before that dismissal. The Compliance Handbook covers this in Section 10. So I want to talk about two things that really sometimes confuse and frustrate HR professionals in business. And one of those two things are for cause and at cost. You can terminate an employee in both circumstances as long as the parameters around them are carried out appropriately. For cause means that somebody has done something wrong, that it violates your policy, your company policy, and you have the right to terminate them for what they have done. At cost means you can terminate them without cause, but it costs you, the employer, to release that person in that moment. In both cases, there are things and parameters that need to be in place in order to carry those actions out. Okay? So again, for cause means the employer has done something. At cost means there is no cause, but there is cost to you, the employer. Okay? Now let's get to severance. Severance is where we find the most exposure sits in Bahamian businesses, and it's where I want to give you accurate information rather than numbers that may not reflect the current law. Under the Employment Act, employees who are dismissed, not those who resign, those who are dismissed, are entitled to severance pay once they've completed the minimum qualifying period of continuous service. The calculation is based on the employee's weekly wage and their completed years of service. The specific formula, the qualifying threshold, and the calculation method are all set by the Employment Act and can be amended. Before you calculate severance for any employee, confirm the current formula directly with the Department of Labor or a qualified Bahamian legal advisor. Our compliance handbook includes the same guidance. Incorrect severance calculations are one of the most significant sources of labor claims in the Bahamas today. What I can tell you clearly is that severance is due on or before the employee's last day, y'all. Stop running these people around for their own money. It's not optional. It's not negotiable downward. If an employee qualifies, they're entitled. When doesn't severance apply, you ask? Dismissal for gross misconduct can remove the entitlement altogether. Voluntary resignation does not attract severance. Redundancy may follow a different calculation. If your business has long-serving employees and you haven't factored in severance obligations, your financial planning may need to change. That needs to happen now, not when the situation arises. The Department of Labor contact is in Section 13 of the Compliance Handbook, found on page 14 as well. The obligations are one part. The process is another. The Employment Act requires dismissal to be for a valid reason, capability, conduct, or genuine redundancy. Dismissing someone without a valid reason or without following a fair process opens your business to an unfair dismissal complaint. The Compliance Handbook lays out a 6-step process. An investigation of the alleged conduct must be done. The employee's opportunity to respond, a reasoned documented decision, a written termination letter stating the reason, final pay covering all outstanding wages, accrued leave, and applicable entitlements must also be included. And retention of all these records must be on file. That's it. It doesn't need to be complicated, but every step needs to happen and needs to be recorded. The disciplinary procedure template we produced walks through this process from verbal warnings straight down to dismissal, with the documentation required at each stage. The link for that is also in our chat. Now, when an unfair dismissal complaint reaches the Department of Labor, your documentation is what the case comes down to. If you followed the process and recorded it, you have a position. If you didn't, then you don't. It's really hard to believe that our 3 weeks are done already. We've had a phenomenal time of learning and developing our skill set as HR professionals over the last 3 weeks, and I want to ensure that you recognize the value that was added to you over these last 3 weeks. If you missed any of our time, you can, of course, go back to watch any of the recaps. But let's do a quick recap of today's session. Work permits must be in place before a non-Bahamian employee starts. Begin the application at least 3 months out so you can have your situation in place. No exceptions. Leave entitlements are statutory. 2 weeks annual leave after the first year. 14 days sick leave. 12 weeks maternity with the first 8 at full pay. Notice periods run from 1 week for under a year of service up to 4 weeks or 1 month's wage for 5 or more years. Severance applies to dismissed employees with qualifying service. Confirm the current formula with the Department of Labor before you calculate anything. And every termination needs to follow a documented 6-step process. Across these 3 sessions, we've covered the full picture: contracts, NIB, the hire to exit lifecycle. You now know what the law requires of you. The next step is making sure your business actually runs that way. TriBlock is built for exactly this. Payroll with NIB calculations built in, the right rates, the right ceiling, filed on time. Leave tracking that counts correctly from the day the entitlement starts. Employment records that keep you ready if a dispute comes up. For a Bahamas-based team, it's the one platform that knows how Bahamian payroll actually works. If you're still running payroll manually or managing HR processes across spreadsheets, and what you've heard across these 3 sessions has made it clear that there are gaps, then TriBlock HR was built specifically for your team. I encourage you to book a demo right now. Right now, book a demo today. See how it works for your business like yours. The link for that is in the chat. Everything we reference across all 3 sessions, the compliance handbook, the HR audit self-assessment, the disciplinary procedure template, and the new employee onboarding checklist is free of charge, y'all. Free. That's free 99. And it's in the TriBlock HR resource library right now. Thank you for being here across all 3 of these incredibly informative sessions. This has been the Compliance Sprint. I encourage you to do the work and get it right the first time. Have a good evening, everybody. Take care.